Hello everyone, I'm Yazan Ibrahim, or as some of you might know me, yazan.abogosh. Today we're going to dive into a fascinating and essential topic, Fraud Examiners Section 2, Criminal Prosecutions. Today's deep dive into the world of criminal prosecutions. Whether you're an aspiring fraud investigator, a business owner, or simply curious about how organizations manage their finances, or if you are auditor, this journey will shed light on the often complex systems that drive decision making. When we think about laws and justice, one key distinction emerges: the difference between criminal law and civil law. Imagine it as two distinct paths within a courtroom. On one path, criminal law addresses offenses against public order, acts considered harmful to society as a whole, like theft or assault. On the other, civil law deals with disputes over private rights, like contract disagreements or boundary issues between neighbors. Within criminal cases, the rights of the accused are critical, and these rights vary across different jurisdictions. Zooming out to a global perspective, we find the International Covenant on Civil and Political Rights, or ICCPR. Picture it as a blueprint for fundamental human rights in the legal world. It's a United Nations treaty many countries follow to ensure fairness in criminal prosecutions. But how well these rights are enforced can differ from one country to another. Key principles of the ICCPR include protection from unlawful arrests, an essential safeguard. People cannot be detained arbitrarily. A valid reason or a proper judicial warrant is required. If someone is arrested, they must be promptly informed of the charges, and this information must be accessible in a language they understand. Now imagine standing in a courtroom during the charging process. This stage determines whether the accused will stand trial. The process begins with a formal document, referred to as a charging document. In common law systems like those in the US or UK, there are often two types: the information, which is a written accusation typically sworn by the police, or the indictment, reserved for serious crimes and signed by a prosecutor after preliminary evidence is reviewed. Meanwhile, in civil law systems, the procedures can differ significantly, occasionally replacing charging documents with arrest warrants or evidentiary reports. Each legal system shapes this process based on its traditions and principles. Prosecutors, imagine them as the architects of the case, exercise discretion at this stage. In some countries like Germany, they are obligated to prosecute if there's sufficient evidence. In others like the US, prosecutors have more flexibility, balancing factors such as evidence strength, trial resources, and deterrence goals. The next pivotal moment in any case comes with the trial process. This is where the rubber meets the road. The dramatic courtroom debates, cross-examinations, and judgment decisions we often see dramatized in movies. However, real-life trials are guided by strict rules designed to uphold fairness. In criminal trials, the accused enjoys the presumption of innocence, the critical foundation of justice. It's up to the prosecution to prove guilt beyond a reasonable doubt, which is the highest standard of proof. Fraud investigations, as you can imagine, are particularly challenging. Such cases typically hinge on circumstantial evidence, often found buried in documents and financial records. A key task during investigations is ensuring that arrests, searches, and evidence collection are done lawfully, as mistakes in this process can be challenged in court. For example, mishandling evidence or conducting an improper search could lead to claims of investigative misconduct, weakening the prosecution's case. Fast forwarding to the verdict and sentencing phase, the outcome of a trial determines guilt or innocence. Imagine the weight of that moment. If found guilty, the court must impose a punishment proportionate to the crime, which could range from fines to imprisonment or even rehabilitative measures depending on the legal system. However, a conviction isn't always the end. A crucial right for defendants is the ability to appeal the decision, essentially seeking a second opinion from a higher court. Incorporating all these stages into a seamless system is no small feat. Legal systems are intricate, weaving together principles of justice, fairness, and practicality. For example, bargaining agreements, commonly seen in common law systems as plea bargains, streamline the legal process by encouraging defendants to accept responsibility in exchange for lighter sentences. This contrasts with civil law systems, where such agreements are far less common and more tightly regulated. Let's not forget the role of the participants in a trial. Prosecutors are not just there to secure convictions. Their primary duty is to pursue justice, even if it means presenting evidence that helps the accused. Meanwhile, defense attorneys work tirelessly to ensure that every legal safeguard for their clients is upheld. Judges operate as the guiding force, and their role may vary depending on the system. In common law countries, judges focus on ensuring a fair process, while in civil law jurisdictions, they play a more active role in gathering and evaluating evidence. With this broad overview, we begin to appreciate the delicate balance of the criminal justice system. A system designed not just to punish wrongdoing, but to safeguard rights, uphold fairness, and ensure that the law serves the people it governs. When we think about legal systems around the world, two main giants stand out: the common law and civil law systems. Though sharing the ultimate goal of justice, they differ in fascinating ways, from how trials unfold to the way evidence is discovered, and even how verdicts are decided. Today, we'll delve deep into these differences, unraveling the intricate components that make both systems unique. Let's start with jury selection, which plays a pivotal role in common law trials. Picture this: a pool of potential jurors with diverse backgrounds, all randomly selected, gathered in a room. But not all of them will sit on the jury. Far from it. Judges can dismiss some at their discretion, especially if they seem unqualified or showcase clear biases. Then there's the for cause process, where jurors can be dismissed for legal disqualifications or demonstrable biases. And of course, another intriguing element comes into play: peremptory challenges. These allow attorneys to dismiss jurors without explanation, though the rules for these challenges vary depending on jurisdiction. On the flip side, civil law systems handle things quite differently. Juries? Rarely used. Instead, cases often rely on panels of judges or a mix of judges and laypersons to decide outcomes. This system streamlines the process with fewer opportunities to challenge or replace decision makers. But jury selection is just one thread in the web of legal differences. Now let's pull on the string of evidence discovery, the phase where cases are built before trial. In common law, this process is adversarial and often dramatic. Each side, the prosecution and the defense, conducts its own discovery, gathering evidence independently. The defense has limited access to prosecution materials, with one crucial exception: any evidence pointing to the defendant's innocence, the so-called exculpatory material, must be handed over. Think of it as a game of high-stakes chess, with each side cautiously revealing just enough moves to move the game forward. Meanwhile, law enforcement gathers evidence under the authority of warrants and other legal mechanisms. Civil law systems take a markedly different approach here. Instead of leaving discovery to the parties, judges step in to lead and oversee the evidence-gathering process. They play dual roles: investigator and arbiter. During pre-trial procedures, judges compile a comprehensive dossier that contains everything: witness testimonies, reports, and the like, then ensure both sides have equal access to it before stepping into the courtroom. In this inquisitorial framework, the emphasis shifts from confrontation to collaboration, with the ultimate aim of uncovering the truth. As we move closer to the trial itself, the differences continue to unfold like the pages of a gripping legal novel. Picture the opening moments of a common law trial. Attorneys from both sides, prosecution and defense, step into the spotlight, presenting opening statements to the jury. They set the scene, each outlining their version of the truth. When it's time for evidence to make its debut, the prosecution takes the lead, presenting witnesses, documents, and other materials. The defense then cross-examines, probing for inconsistencies and alternative interpretations. It's a performance as much as it is a legal procedure designed to sway the hearts and minds of the jury. In civil law, trials strip away a lot of the theatrics. Here, judges take a central commanding role. Instead of evidence being introduced piece by attorneys, judges present the pretrial dossier and directly question witnesses, stepping in to clarify details or chase down uncertainties. The process is less adversarial, more streamlined, and guided heavily by the judge's authority. But whether dramatic or methodical, all trials eventually lead to a verdict. In common law, the jury's responsibility is immense. They must reach a unanimous decision to either convict or acquit the defendant. If they can't agree, resulting in what's called a hung jury, a mistrial is declared, opening the door to a potential retrial. Civil law, once again, simplifies things. Verdicts are typically rendered by the judges or mixed panels instead of by a jury. Deciding guilt often doesn't rely on unanimity. A supermajority vote is enough to deliver justice. This change reduces deliberation time while maintaining fairness. Even sentencing varies widely between the systems. Imagine this. In common law courts, after a guilty verdict is reached, the trial takes a pause. A separate sentencing hearing is held where the judge takes on the role of evaluator. Reports are reviewed, covering everything from the defendant's character and criminal record to victim impact statements, which vividly detail the emotional, financial, and social consequences of the crime. Prior convictions rarely affect the trial itself, but can heavily weigh on sentencing decisions, especially in shaping the punishment's severity. Civil law treats sentencing differently, merging it with the trial itself. Evidence of prior wrongdoing can emerge during the main proceedings and factor directly into how guilt and punishment are determined. It's a more consolidated process, but one that seeks justice without unnecessary delay. Penalties within both systems reveal another layer of complexity and cultural divergence. In common law, options include probation, imprisonment with fixed or flexible terms, parole, fines, restitution to victims, or even forfeiture of property used in crimes. Parole, offering conditional early release, stands in clear contrast to probation, which spares imprisonment by enforcing conditions like good behavior under supervision. Civil law systems may embrace similar sanctions, but the way they're applied varies based on context and tradition. Finally, appeals represent the last line of defense for those seeking justice. Both systems allow convicted individuals to challenge decisions, though approaches differ. In common law, appeals focus on legal issues, examined through fresh eyes by appellate judges. They rarely revisit case facts, emphasizing whether the trial followed proper procedures. Contrastingly, civil law appeals dive deeper, enabling a full review of both legal and factual matters to ensure every detail has been accounted for. By weaving together these elements, the contrasting philosophies of common and civil law emerge clearly. One thrives on the adversarial drama of courtroom battles, while the other emphasizes judge-led inquiry and collaboration. Both, however, strive toward the same lofty goal: justice. Together, let's explore and understand these distinctions as they shape the foundations of legal systems worldwide. Thank you for watching, and as always, continue learning, stay curious, and we'll see you next video.